Good morning. I'd like to thank Boulder Rights of Nature for hosting this forum and for inviting me. It's indeed timely. We're facing a future with more people and less water. And there's an active dialogue going on now all over the state about how we're going to deal with this. And we need to be part of that dialogue, or we may not care much for the resulting future, particularly if we don't protect stream values on both sides of the divide. But in order to participate in the ongoing water dialogue, to speak up for our rivers and riparian habitat, we all need to understand the basics of Colorado water law. Otherwise, it would be like saying, I really want to play football without having a clue about what the rules were, what was legal and what wasn't legal, even what were those things down at the end of the people kick balls over. So we all need to know the rules of the water game because we all need to be part of that dialogue. So my goal is that in the next 30 to 45 minutes, you will understand the basics of Colorado surface water law. If, by the way, you came here because you were really interested in groundwater, I'm sorry, we're just going to be talking about surface water, water in our streams and natural lakes. People always seem to feel that Colorado water law is diabolically difficult. It's so complex. Actually, our surface water law is logical and eminently understandable. You just need to understand the framework and some basic vocabulary. And my friends, you'll be good to go. Our system makes sense in a water-poor area, and we're a semi-arid state. I think, honestly, that it's not the complexity of the topic, Colorado water law. It's the complexity of some of the explanations about the topic. So this morning, we're going to have a very, very simple explanation. I call it the run, spot, run version of Colorado water law. It won't even hurt, trust me. And in order to try to keep this to a reasonable degree of time, I brought a timer, and I'm going to break it up into certain amounts because I know how far I need to go. Otherwise, we will still be talking about the first point when I should have been finished. Because actually, water law is pretty exciting and a lot of fun to talk about. So, in Colorado and in most of the West, water law is governed by the doctrine of prior appropriation. That's true in all Western states where the water is scarce, as opposed to back east where the water's more plentiful, and they have a different system. Now, I'll grant you that the doctrine of prior appropriation does sound a little bit stodgy. But stop and think a minute. What does the word appropriate mean? Webster's dictionary. It means to take for one's own use or to set aside for some special use. Guess what? It means exactly the same thing in Colorado water law. The doctrine of prior appropriation allocates water use based on chronological priority. It's a system of administered water rights. And there are 4, not 40, not even 14, 4 basic tenets to the administration of Colorado water rights. Number 1, a water right is a property right, but you own a use of the water. You don't own the drops of water. That's the single hardest thing for people to kind of grab onto. We're used to a property right being, it's my property and here it is. It's the use. It's a specific allowed use for a specific purpose. You don't own the drops of water, you own the use of the water. Do you know who does own the drops? We all do. It's in the Constitution of the state of Colorado. It's Article 16, Section 5. And it says that the water and the natural streams and lakes of Colorado belong to the people of Colorado, to be used in accordance with the doctrine of prior appropriation. So, in order to use even a drop of water, you have to have a water right. And what's a water right? A water right is a right to use water. That's number one. Number two, it's called the doctrine of prior appropriation, that use is in priority. That's also called first in time, first in line. We'll talk more about what these mean in a minute. Number three, you can't injure existing water rights. Now, a water right is a right to what? It's appropriate water. Take it and use it. And your right to take it and use it can't interfere with anybody else's right to take it and use it. What is protected from injury in Colorado water law is the right itself, the right to use water. And finally, that's three. Number four, use it or lose it. If you don't use the water, you can lose the right to use it. Why? Because a water right is a right to use. It's not a right to hoard. Those are the bare bones of Colorado water law. But it's pretty abstract. So, and by the way, that took like 4 minutes, and you've got the basics down. Let's see how a water right is actually established. Today, in all honesty, you wouldn't go out and establish a new water right. You'd buy it from somebody else. But I think that the scenario in which you explain how a water right is established will make all of these terms that we talked about, including the 4 tenets, make sense. So let's say that Farmer John wants to take water out of Babbling Brook and use it to irrigate his cantaloupe. Back east, he'd need to own property along the banks of Babbling Brook. Not here. Here, he only needs the right to divert the water from Babbling Brook. Diversion is one of those legal terms, but again, it's a dictionary definition. To divert, according to good old Webster's, means what? Well, it means that you're going to divert it from what it was doing, babbling along. You're going to change it. Actually, the definition, I wrote it down, is to rewrite or turn aside from its course. Well, that's what we're talking about. Instead of babbling along, John's going to take that water and divert it to watering cantaloupe. Diversion means to control that use of water. It could be in the stream, like a recreational channel diversion, or like a generation, a hydropower generation, or what John's going to do, which is the more common one, which is to divert it out of the stream to his use. Well, what does he need? Back east, he would have to own property along the banks of Babbling Brook. Not here. He only needs the right to use the water that he's going to divert from Babbling Brook. So, how does he get that right? Well, he has to go to water court. And he will ask the water court for that use. Now, the process is as follows. The water court's going to want to know a few things, and they're about what you would guess. They're going to want to know how he's going to use the water. Because in Colorado, a water right is a right to use water. So, there is another term in statute, is beneficial use. Beneficial use in water law is not, my friends, a Webster's dictionary definition. It's a term of law. A beneficial use means the use of water that is reasonably needed for an approved purpose. And what are those approved purposes? They're in statute, and they're about what you'd guess they would be: domestic, municipal, agricultural, industrial, recreational, and environmental. So, beneficial use is not what John thinks would benefit him. It's not just a good idea. It's a specific statutory term, and one more time, folks, it is the amount of water necessary for a statutorily approved use. Okay? So, now he also has to tell them how much he reasonably needs to use it. He would meet the general qualification of agricultural, but it doesn't mean that he can take all the water that he wants out of the stream simply because it's an agricultural use. He will get a right to do exactly what he needs to do, water cantaloupe. The amount of water that he needs to water cantaloupe, that's what he'll be able to get under the beneficial use standard. So how much he needs to use, when he's going to take it out, where he's going to take it out. Now, since John's right, if he gets it, will be a right to use water to irrigate cantaloupe, anything that the cantaloupe don't take, he has to let return flow back to the stream. Why? Because if he gets it, his water right is a right to water cantaloupe. So if he has extra water that year, the cantaloupe don't happen to take as much, can he keep it and say put it in a swimming pool? No. His right wasn't for a swimming pool. His right, if he gets it, was to irrigate cantaloupe. That water will flow back. It's called return flow, the water that flows back to the stream, where it will be used by the next appropriator, take for his use, in line, chronologically. That's why it makes so much sense in a water-poor state. And finally, there can be no injury to existing water rights. We talked about that no injury standard. Other people already have rights on Babbling Brook. What John does can't interfere with those rights, their ability to take water out of Babbling Brook and do something with it. Now, if the court grants his decree, it will be conditioned upon his doing what he said he would do. Water cantaloupe. And guess what you call that water right that is conditioned upon his doing what he said he was going to do? It's a conditional water right. Makes sense. The condition is that he applies the water as stipulated in his decree. That's the legal way of saying it. He does what he said he was going to do, is what it means. Now, his right will be final when he actually pours the water on his cantaloupe, when he uses it. And when he uses it, it's absolutely his, and it's called an absolute water right. A conditional water right, I'm going to use it. An absolute water right, I used it. What's the big difference between the two? Well, a conditional right says you're going to do it. If you haven't done it within 6 years, you have to go back to water court. And you'll say to the court, Judge, Your Honor, I am diligently trying to get this water to my cantaloupe, but things have come up, and for this reason, that reason, or the other reason, I didn't do it. If the court says that's reasonable, he gets another 6 years, and another, and another, and another, if necessary. Not surprisingly, the environmental community likes diligence hearings because it keeps people from hoarding, and the water development community doesn't particularly care for them, and they're always trying to either extend the amount of time from 6 years to 6 million or something along those lines. Get rid of it altogether. So, the water court will assign a date to the right that John has. That date is its priority. John's right will be junior to everybody that already had a right on the stream, and it will be senior to everybody who gets a right after he does. So suppose that John gets his right this year, and it's a 2014 right, June of 2014. Now suppose that I get a water right next year, about the same time, so my water right would be a 15, joking, actually add 14 and 1 sometimes. You will get a water right, I will get a water right that's 2015. Now suppose that my right is right up at the top of the stream. There's always water at the top of the stream. It's pure and cold and wonderful, flowing down. And John's right, it's all the way down at the bottom of the stream. If there's not enough water to go around for both of us, only one of us will get the water. You'd think it would be me. I'm up at the top of the stream, not John. It isn't. The rights are in priority. The older right will be filled before the junior. That's the doctrine of prior appropriation. Now, I mentioned change cases, that you could, in fact, these days, just buy a water right. Well, suppose somebody wanted to buy John's water right, but they didn't happen to want to water cantaloupe in Boulder in June. They wanted to do something else with it. So what on earth good would John's right be if his right is a right to water cantaloupe? Well, you can change it. Now, here's how that happens. And we're going to tell another story, and this one will be about another farmer, Farmer Fred. I'm going to say that Fred owns I'm going to give myself another 2 minutes on this. My rights are senior. Fred's right is a right to water alfalfa, and it's an old water right. He's had it for ages. And it's a big right because alfalfa takes a lot of water. But Fred's getting tired of farming. It's a lot of work. And what he'd like to do is to, instead of growing alfalfa, put in a subdivision and use that water right of his to plumb houses. Can he do that? Well, yes, if his water right is a right to water alfalfa, not houses. So he needs to go back to court and ask for what? A change of use hearing. At that hearing, everybody who owns water on Babbling Brook who might be impacted by Fred's proposed change gets to stand up and say, "Excuse me, I think I might be injured." He cannot injure anybody. John is way, way junior to Fred. But if Fred changes from what he was doing to this new use, he has to do it in such a way that it does not injure John's right. That's the no injury standard. Very, very critical part of Colorado water law. Now, suppose that I live right next door to Fred's alfalfa field. And I don't like the idea of a subdivision going in. I liked having it be rural. I liked having it be an alfalfa field. I think that my property might be worth less. I'm going to be injured by that. Can I go into water court and say, "Excuse me"? No, absolutely not. I don't have standing to do that. Only other water rights holders. Only other water rights holders. Okay, well, suppose that I have a little water right, a little surface water right. I'm taking water out of, excuse me, the same ditch that Fred is. So it's enough for me to water my garden, like maybe 20 buckets of water. Can I go to a water court to have standing? Yes. Can I complain about the traffic? No. Can I complain about the impact on, the cottonwoods and the riparian habitat? No. If what Fred does means that I wouldn't get my 20 buckets of water, I can complain. And he must be sure that I get my 20 buckets of water when I was going to get them before. But that's all. That's what's protected from injury. And finally, John has to use his water or he can lose it. Why? You know why now. Because in Colorado, a water right is a right to use water, not hoard it. It isn't his to hoard. It's his to use. So, a little postscript here. And we did make it in time. So, I get some time for my postscript. In our discussion of water rights, did you notice that there are a few rights missing? A river can't own a water right. The fish in the river can't own the water right. The birds that live in the riparian zone next to it can't own a water right. If the legal exercise of a water right simply dries up the stream, the fish die. In 1973, the legislature, the state of Colorado, did something about that. They passed the Colorado In-Stream Flow Act. Now, you remember that a water right is a right to divert water to beneficial use, to take it out or control it in the stream and do something with it for that use. Has to be a beneficial use. What the legislature did in 1973 was to say that an in-stream flow is a beneficial use. And we're not going to take the water out of the stream with an in-stream flow. We're not going to control it in the stream. We're going to let it flow. That's an in-stream flow. Who can have one? I'd like one. Yeah, no. It's a public water right. Belongs to the people of Colorado, but it is held on the behalf of the people of Colorado by the state of Colorado, by specifically the Colorado Water Conservation Board. It's a state water right, and the beneficial use, because it has to have a beneficial use, right? That's the whole purpose of what we've gone through. Well, the beneficial use statutorily created by the legislature in 1973 is to preserve or improve the environment to a reasonable degree, there's still that reasonable standard, by allowing a specific quantity of water to flow past 2 points. To flow past 2 points between A and B. That's it. People tend to think that the Colorado in-stream flow program is for the whole stream. It's not. It's an actual water right, just like John's water right, just like what we talked about. It has a priority date, it's for a specific purpose, and the use is in priority. The measure of an in-stream flow is cubic feet per second, because we're talking about flow. All of you got, or will get later today, a copy of the Audubon Water Handbook. If somehow you don't get it, call the Audubon office in Fort Collins. There's no charge, and it's a useful reference. And if you were to look up in the dictionary section of it, cubic feet per second, you'd see that CFS is a measure of the rate of flow of a cubic feet of water past a specific point. 1 CFS amounts to the volume of 1 cubic foot. Visualize a basketball, sort of. 1 cubic foot per second. It's passing a point per second. It's been estimated by NWF some years ago to be about the equivalent flow of 30 garden hoses going at the same time. So also in this, you will find a complete explanation of water rights in the stream, much more than we're going to talk about today. So I advise you, hope that you will get it, and please read it. It's the run, spot, run version of Colorado water law written down. So now, many of the earlier in-stream flow rights were only for cold water fisheries, and they were for very small amounts. The statute didn't say only for cold water fisheries. The statute says to preserve or improve the environment to a reasonable degree. But nevertheless, many of the early rights were R2 crosses for fish rights, cold water fisheries. So they weren't as broadly allocated as they might have been. They have a priority, but that priority is largely junior to the other water rights because the in-stream flow program wasn't created until 1973. So I can show you streams in Colorado with a perfectly valid in-stream flow right that are completely dry during the time that a lot of water is being taken out of the stream. Why? Because they're junior to those rights. So that's a limitation. However, because the use is in priority just like any other water right, just like John's water right. But remember Fred? Remember Fred and how he was going to change the water right? And when he changed his water right from alfalfa to subdivision, he had to go to water court, and he had to make sure that he did not injure what? Any other existing water right. That includes in-stream flow rights. So just as John's right was junior to Fred's, it still was protected from injury in a change case. That is no small right, folks. It's important. Remember change cases. And remember that an in-stream flow, even though it's junior, can protect in that instance. So it's important that you understand both the strengths and the weaknesses of a very, very valuable tool. There are about 8,000 miles of stream in Colorado, a little over that actually, that are currently protected by some level of in-stream flow for a segment of that stream. Not the whole stream, a segment. That's about a quarter of the stream miles in the state. We'd like to see more in-stream flow rights. But remember, when you go in, as I know you're going to do, and discuss before some of these water forums, and you hear, oh, well, we have an in-stream flow, ask the priority. That's important. So we should expand it where possible and read it, in my opinion, more liberally. Improving the environment to a reasonable degree means a lot more than survival flows. Survival flows, easy for you to say. Survival flows for fish. So that's the basics, my friends, plus a little. You now know the framework. You know what the doctrine of prior appropriation is. You know that appropriate means, it's a fourth grade spelling word, not hard. It means to take or set aside for one's own use. It means the same thing in water law. That use is in priority. You know that it's a system of administered water rights, and there are only four basic tenets governing the administration of those water rights. And you know what they are. You own a specific use in priority. You can't injure other water rights. And if you don't use it, you could lose it, because a water right is a right to use, not a right to hoard. And it is an actual property right. You know the basic terms: diversion, diverting to a use by controlling or removing. You know beneficial use. It's the reasonable amount of water reasonably needed for an approved purpose. It's not just what somebody thinks is a darn good idea. You know what a conditional right is. And by knowing that, you know more right now in this room than many other people. A conditional water right is a right that you say, I'm going to do something. It's based on you're actually doing it. It's good for 6 years. You have to go back for a diligence hearing if not, if you haven't used it. An absolute right is absolutely yours. You don't have to go back. And what's the difference in absolute right? Well, an absolute right, you've used the water. Once John pours the water on the cantaloupe, he doesn't have to go back anymore for a diligence hearing. It's his. And you know that in-stream flow is a public water right. It is the only water right in the state of Colorado that does not require any diversion. It's the flow between two named points. It's to preserve or improve to a reasonable degree. That's the approved purpose, the beneficial use. So now that you know the basics, you can be part of the dialogue. Our streams do more than keep fish wet. They're the heart of vital riparian ecosystems. 90% of the wildlife in Colorado depends on riparian habitats to survive for at least part of their life cycle. Riparian zones are a very small percentage of the total land area in Colorado, but both environmentally and economically, they're critically important. I came across the figure that in a federal study that in 2011, Coloradans spent $10 billion on wildlife recreation, to say nothing of what was spent on, say, rafting. And that wildlife is 90% of that wildlife depends on those riparian areas. Yes, a water right is a property right. It's a right to use, but it's a property right. It can be bought, sold, and transferred. And it can be conditioned. We condition other rights. Real property is conditioned. Zoning laws, for example. Even basic constitutional rights such as free speech and freedom of religion, freedom from search and seizure, have conditions. A property right can be conditioned. And finally, those drops of water that make up the stream, you own them. We own them. You own them. You own those drops. I fervently hope, that you will join the conversation on how your water is used. Thanks very much, and I'm glad to have had the opportunity to talk to you today.